Good morning and good afternoon to everyone. Thank you for joining us today in our second in the EDI series, Is This Too Personal? A look at the benefits and pitfalls of EDI data collection. My name is Erin Porter, and I'm the chair of the Ontario Labour, Employment and Human Rights Group. I'm a partner here in Toronto and spent a lot of time advising on labour and employment issues. I'd like to provide a land acknowledgement before we begin. First Nations and Inuit have been present in Canada for thousands of years. These Indigenous peoples have a profound and ongoing attachment to the territory. At Fasken, we recognize that we have a role to play in the ongoing process of reconciliation between Indigenous and non-Indigenous communities, and here and elsewhere in Canada. We have embarked on a journey by adopting a plan with the overall purpose of contributing meaningfully to reconciliation. So I'd like to draw your attention to the survey link. So you can see that there's a tab to complete. Please take the time to provide feedback on our session. It's important, and we do take it to heart to try and improve future programs for you. We also have an automated process for those who in Ontario and Quebec for CPD certificates. So make sure that you take advantage of that. At the end of the webinar, there'll be a QR code that will appear on your screen, and a link will be added to the audience chat that will allow you to receive a certificate once you provide your information. For those of you who aren't able to complete this process today, certificates will be sent next week. And so while I leave this slide on the screen for you to take a few minutes to look through the rest of the items there, I want to introduce my fellow co-speakers. We're very fortunate to have Daniel Fabiano joining us. Daniel is a partner in Fasken's privacy and cybersecurity group, one of the many groups that he's actually a part of. So Daniel's a person who wears many hats. And he advises on a wide range of business, nonprofit associations, and public sector agencies. He helps clients develop and manage privacy compliance programs, navigate risk, and make strategic decisions about their use and communication of personal information and de-identified data. So he's a perfect individual for us to have here today. He'll provide a lot of expertise. And then I'm also really pleased to welcome Nicole Singh. Nicole is one of the partners in my group, so I'm fortunate to be able to work with her quite frequently. She regularly advises public and private sector employers on a wide range of issues that touch on labor, employment, and human rights. She is also very experienced with collective agreement interpretation, employment contracts, employment standard complaints, human rights complaints, wrongful dismissals, so the list goes on and on. Nicole has represented clients before arbitrators, courts, and the Ontario Labour Relations Board. She also advises clients on issues arising from corporate restructuring and mergers. So with that, we will now move on to our presentation. Our agenda for today is on your screen. So we're going to try and take some time to go through and answer the questions that you see before you. So starting off with, why should employers care about EDI data? And then how can employers collect and protect the data? How can they use the data? How can they secure the data? And then finally, talking a little bit about some of the challenges that you may come across. So to begin, why should employers care about EDI data? For those of you who joined us in the first of our series, EDI Basics, you will probably recognize this slide because it was also put up in that presentation. But I thought it was important to share it again because it really talks about one of the kind of underlying benefits to collecting EDI data and making sure that you are focusing on EDI. And that's that it just makes good business sense, right? It helps companies be profitable and be successful. And if you look at this, you can see the statistics, right? Gender diverse leadership teams are 21% more likely to outperform. Racially and ethnically diverse companies are 35% more likely to perform. Inclusive companies are 1.7 times more innovative. So the statistics go on and on that demonstrate that really it's good business sense to have EDI practices in place. And by collecting data so that you can inform any decisions around programming, you can inform those decisions because of the actual numbers, then that will help you actually move the needle on a lot of these functions. It also allows you to help measure the performance. So are the programs and policies that you're actually putting in place worthwhile and successful and doing what it is that you would hope they would achieve? Collecting EDI data is also the right thing to do. So it's I put a case up here, and this is not a case that talks about collecting data from an EDI perspective, but rather collecting data on a police force. And so this is a case about a police force that was collecting statistics on people who were pulled over in traffic stops to determine whether or not the police force had an issue with racial profiling. And so while it's a different context, I think that some of the comments and some of the reasoning that the tribunal highlighted in this case resonate with why employers may also want to collect this data. And so here I've got a quote from the tribunal up on the screen, and it says, "The tribunal is of the view that the collection of data concerning perceived or presumed race of persons subject to police stop is a necessary measure to better document the extent of racial profiling within the SPAL, to further raise police officers' awareness of this phenomenon, and to better equip them to fight it." Right? So to understand, you collect the data so that you can understand, is there a problem? Are people aware that there's a problem? And then if there is a problem, how can we address it? Because if you don't know the statistics and you don't know the information, then it's really difficult to actually effectively make change to correct it. And we saw this when we started to implement legislation that talked about pay gaps based on gender, right? So when we looked at things like pay equity legislation and pay transparency legislation, the statistics show that it actually narrowed the wage gap between men and women. Unfortunately, we don't have similar sort of evidence to base to understand the challenges and the gaps that may exist when we're looking at other types of diversity. So if we're looking at disability, sexual orientation, ethnicity, socioeconomic classes. So once you start to gather the data and have information to actually inform your decisions, then I think you are putting your organization in a better position to actually affect change. And there's a quote that's often used when you're talking about the collection of data and why you do it. And it's, what's interesting is that organizations that make a point of tracking and reporting on the results tend to have higher levels of diversity. What gets measured gets done, right? So I think that is really sort of a founding principle to why employers might want to consider starting to collect EDI data. It could also, you could do it for a self-serving reason. It could protect you. And so this case here talks from the Canadian Human Rights Tribunal is a case that was brought by an applicant who had gone through the hiring process and was not successful at the end of the process. So he made it through several different stages of testing and interview scenarios, but then ultimately he was not a successful candidate. And he alleged that the reason that he wasn't successful had to do with his race and ethnicity. And the employer was able to provide data that it had collected to say that it actually had a fairly diverse workforce, and that the evidence showed that there was no, at least systemic discrimination based on the grounds that he was alleging. And while the tribunal said that it's not determinative, just because you have what on paper may look like a diverse workforce doesn't mean that there wasn't discrimination. But they did say that it helped to address the allegations that this was a system-wide issue that the employer was favoring people from one background over another. And so that I think is an interesting thing to keep in mind as well, that it could help to act sort of as a shield from claims in the future. And then we also may want to consider collecting EDI data because it helps us to identify issues we may not even be aware of. So again, when you think back to the police force who started to collect data to see whether or not there was an issue with racial profiling, then this may give you insight into areas that you didn't know you had an issue. And we think about different parts in an employee's life cycle with the company, and those are sort of pain points where you're like, okay, what sort of statistics can we gather to support or to find out information about different stages? So what about at hiring? What about during performance reviews? What about if we're looking at promotion or leadership positions? So there are all these different data points that really can sort of inform an employer and help them to make decisions. As I mentioned earlier, it also allows you to measure the impact that your programs and policies will have. So, you put a lot of work into these programs. Are they paying off? Are they achieving what you hope they will achieve? And the data really can help you determine that. And then finally, it helps you retain top talent. And there have been a number of surveys that have come out post-COVID that talk about employees and what it is that employees are looking for in an employer. And a survey done, I believe it's in 2021 by Ipsos it's a World Economic Forum. And they determined that 40% of employees said they would likely quit their job if they felt that the company was not prioritizing social and racial justice. So 40% of employees now have indicated that that's a value that they would quit over. And 80% of US employees believe that company leaders have an obligation to play an active role in dealing with sort of systemic injustices. So I think that it is something that is worthwhile for employers to keep in mind. And there's a lot of really good reasons why many are now considering to start collecting or to augment, if they're already collecting, to augment the collection of EDI data. So we'll move now to how employers can collect and protect EDI data. And I'll just talk briefly about the human rights legislation before passing things over to Daniel. So as you probably know, human rights legislation in Canada is in different buckets. So we would first have the Charter, and that applies, it's a federal piece of legislation that applies across Canada, but only to certain organizations. You have to be sort of a government or quasi-government entity. And so that legislation stipulates that you can have special programs or opportunities for people to be treated with some preference if it's serving the goal of creating a more level playing field. So looking at sort of trying to right historic and longstanding systemic issues. There's also then the Canadian human rights legislation, as well as federal legislation around employment equity. And then each province has its own human rights legislation as well. And so the Ontario human rights legislation specifically says that it's not an infringement to create special programs, again, to address some of the historic hardships or economic disadvantages that may have been have an impact on people from protected grounds. So with that, I will pass things over to Daniel.
Thank you, Erin. So I'm the privacy expert on the call, and I'll try to shed some light on what Canadian privacy statutes might say in terms of EDI programs. And maybe I'll start by saying that as a general matter, privacy law does not prevent employers from collecting EDI data in the right circumstances. And in fact, in some provinces, there may not even be a privacy statute that applies. Now, of course, if a privacy statute applies, then it will be important to collect and use and share any EDI data according to the requirements of that statute. But as is often the case when I get questions from clients about privacy, the first step is to determine if a privacy statute applies, and particularly which one. Or if you're a national enterprise, which ones, because there may be multiple that overlap. Canada has a patchwork of privacy laws, and this is why it gets a bit complicated. And in fact, it is more complex in an employment context than it is perhaps in a consumer context where you're thinking about the privacy of your individual customers as an organization. Employment is more nuanced. So because this is a short presentation and because the audience is diverse, I'm going to be speaking about privacy statute requirements in fairly generic terms. But in your role as an employer, it is important that you know what privacy statute applies to your organization. Again, your organization as an employer. You may be subject to privacy statutes in other respects, again, with regard to your customers, but it's important to know which privacy statute applies to your organization as an employer. There is variation across Canada. So to help make sure we're on the same page, and if you're not sure what statute applies, to help you sort out what might be the relevant statute, I'm going to start by summarizing what I call Canada's privacy patchwork. I'm doing this to level set because I often encounter, more than I would like, a situation where I'm speaking with a client and they believe that the federal private sector statute applies to them as an employer, and it does not. So if you're familiar with all this, bear with me. But if you're not, hopefully this will be useful. So Canada's privacy statutes, when it comes to employment, fall into three main buckets. The first bucket is federally regulated private sector employers. Those employers are governed by a federal privacy statute, the Personal Information Protection and Electronic Documents Act. It's also known as PIPEDA. And if you're a bank or you're an airline or you're some other federally regulated enterprise, this is your law when it comes to employee privacy. Now, if you are a provincially regulated private sector employer, you are not governed by PIPEDA when it comes to employment-related activities. You might be governed about other things, customer-related things, but not when it comes to employment-related activities. And this is the misconception that I mentioned earlier. And this, incidentally, it's because the federal government does not regulate provincially regulated employment, which means the federal privacy statute can't touch that sphere. There's another quirk here as well when it comes to provincially regulated employers. Only 3 provinces have their own provincial version of PIPEDA: Alberta, British Columbia, and Quebec. So in those 3 provinces, a provincially regulated private sector employer would need to conduct themselves according to that province's statute. In other provinces, including in my case where I work in Ontario, there is no provincial statute, which is a surprise to some people. And that means you're in a no privacy statute zone. So if you're a provincially regulated employer and you've got no employees in Alberta, BC, or Quebec, then virtually everything I say in the course of this presentation is a best practice for you and not a statutory requirement when it comes to your employees. Now, of course, given the sensitivity of EDI personal information, it is a particularly compelling set of best practices, but a set of best practices nonetheless. There's a third bucket, which may apply to some in the audience, and this is for public sector employers. Public sector has its own privacy law. Those privacy laws tend to apply in a limited or partial way to employee personal information. So as an example, if you're a federal public sector entity, it's the Privacy Act. If you are a provincial public sector entity, then if you're in BC or if you're in Ontario, it's the Freedom of Information and Protection of Privacy Act. If you're in Ontario and you're at the municipal level, there's a municipal version of that act. The point I'm making here is that the public sector has its own regime and it's a bit different. One other point you'll hear me talk about, you'll hear me constantly refer to employees, but I just want you to know that whenever I say employee, I also mean applicant. I mean employment applicants. The same rules apply to employees as to applicants. And I'm going to add one more complexity, and I'm sorry to do it. And it's for any of you who side with relief because you're in a no privacy statute zone. That zone is specific to employment relationships. It does not cover independent contractors. So if your EDI program involves collecting EDI personal information about your independent contractors, you still have to comply with PIPEDA. And so the rules that I'm talking about today then are relevant for you. So apologies if I've just, ruined your sigh of relief, but I just wanted to make that caveat. So suffice it to say, Canada's privacy patchwork is complicated, but hopefully this has helped you sort of organize your thinking as to where you sit. Now let's turn to the key term, which is personal information. And you'll see me in this slide, I'll reference PI, personal information. Personal information is information about an identifiable individual. Now you can be identifiable because you are directly identifiable. You are named, the individual is named, and so that's personal information. But it's also the case that it is still personal information if the individual is indirectly identifiable. And you'll see in the parentheses, this is the test that the federal commissioner uses and is generally used provincially as well. So how do you know if someone's indirectly identifiable? Well, the test is if there is a serious possibility that the individual could be identified, whether by using the information at issue or by using other available information that lets you triangulate to the identity of that individual. So if it is hard to triangulate the identity, then you may not be dealing with personal information. If it's kind of easier to triangulate, then privacy laws would say, well, it's still personal information. I make this point because if data is not personal information, if you don't fit within the test on the slide, then privacy statutes no longer apply. You're free to handle the data without regard to those statutes. So I find that it's useful to think about whether you're dealing with personal information or not by picturing a spectrum. And at one end of the spectrum is personal information. The individual can be identified fairly easily. The tests that I cited above work, and you'll see them in the bottom left, in the red zone. If it's personal information, of course, privacy law applies. But what happens if enough identifiers are removed so that the information is no longer directly or indirectly identifiable? If it is impossible to tell who the individual is, then you're dealing with anonymous data. And as I say, privacy law never concerns itself with data that is anonymous. So this is important. If you limit your EDI program to collecting truly anonymous information, then you will lower your privacy risk to zero. Truly anonymous information is not subject to privacy law. Now, if you're not going to that extent and you are collecting information, but you're removing identifiers, then you're sort of in the middle, where the individual may or may not be identified. And we call this de-identified data. And I put this up because often some folks will think de-identified and anonymous mean the same thing, and they don't. It's a spectrum towards anonymity. De-identified data is somewhere in the middle. So you've taken off people's names, but maybe you're still using employee numbers in the data fields. That is de-identified data, perhaps not anonymous data. And so this is where you're thinking about that serious possibility test. How hard is it to figure out whether the individual is identifiable? And so that the spectrum is hopefully helpful. There's also a twist. Some of you, particularly if you have operations in Quebec, you may have heard about various efforts to modernize Canada's privacy laws. And those modernization efforts were completed in Quebec a couple of years ago. This is Law 25 or Act 25, which some of you may be familiar with. You also may be familiar with the federal government's efforts to modernize PIPEDA, and they've been trying that for years. This modernization effort, for better or for worse, is taking a bit of a different approach to de-identified data. And the idea is that if it's still possible to identify the individual, then the data should be treated a bit more like personal information. And so those laws are tightening up the regulation of that middle zone, and they still will apply. And so we'll see whether PIPEDA gets modernized before the next election. But all of this to say that if what you're collecting or using is de-identified, in my view, you should still treat it as being personal information. And so you should follow the rules that we're speaking about here. I'm going to make one final point, and I apologize if this is a bit overly technical, but I make this point because there's a lot of reference to aggregated data. Aggregated is just another word for saying that the data that you're looking at is from multiple people. It just means multiple people's data has been combined together into a data set. That data set, though, could still be identifiable or could still be de-identified. It may not necessarily be anonymous. And we had a question come in before the session about aggregate reporting, and the question asked about best practices for aggregate reporting. So when it comes to identity groups who may have small numbers, there's more of a chance that you'd be able to figure out which individuals are in that small group. And so the question was just, what are the best practices? To be frank, this is kind of a statistics question, and I'm a few decades from my last statistics course. But the key issue here is, how have you described your EDI program and your approach to data to your employees? If you described your program as only involving anonymous reporting, then it will be very important that when you aggregate the data, you aggregate it so that the result is anonymous data. And very often what I find is that some folks will think aggregate and anonymous are synonyms, and they're not. Aggregate just means the data is about multiple people. You still have to look at the data set and decide, is this anonymous or is this just de-identified? Or frankly, is it even still personal information? An aggregated data set of two individuals' data is probably still personal information. Probably could still figure out who those individuals are. An aggregated data set of, 12 people might be de-identified data, but probably isn't anonymous data. Those are made up numbers. What matters in your context is just that, your context and your circumstances. Those are crude examples. The point I'm trying to make is that how you treat your data needs to be consistent with how you described it to your employees, and you shouldn't mistake the notion of aggregating data for being anonymous. And so if you've told your employees you will only handle data on an anonymous basis, you should double check your approach to make sure that that's actually what you're doing. So we're going to leave some of the more technical aspects and move on to things you should do and things you should think about in terms of what the privacy statutes require. First off, the privacy statutes require that the purposes for collecting and using and disclosing personal information be established. And this means that the purposes have to meet certain criteria. First, they have to be documented, meaning the organization has documented its own EDI program. There is forethought, there is intentionality. You have decided and documented what are the types of information we're collecting, what are we using it for, how are we reporting on it, who are we sharing it with. All of that is documented in your program documentation. The second piece is that the purposes that you're collecting and using and sharing EDI personal information have to be appropriate, they have to be reasonable, and the data that you collect and the data that you use has to be necessary to achieve your legitimate purposes. Don't over-collect data. Don't collect data unless you have a stated purpose for using it. And the final piece is that the purposes need to be clearly stated in notices and in consents that you provide to individuals so that they understand what the purposes are about. As a general matter, collecting EDI personal information is not a legal obligation. It is more of a voluntary program, a very valuable program, but not something that, as a general matter, is required by law. And so eliciting EDI data from employees is really a voluntary exercise. And I suppose you could mandate that your employees complete EDI surveys on the whole. In my view, you would need to make sure that your individual questions about EDI elements allow individuals to decline to answer those questions. So they could click decline to answer on a particular response. And because you're requesting EDI data from employees without a legal requirement to do so, you're basically doing so with their consent. It's voluntary, and so you're doing it with their consent. And because EDI data is sensitive in nature, often, privacy statutes would require that it be collected with express consent, which is to say opt-in consent by taking an affirmative action which shows that the individual understands what's happening. So you would explain the purpose. If let's say there's an electronic survey, at the top is an explanation about what's happening, and perhaps there's a checkbox where the individual can say, yes, I've read it and I agree and understand what I'm consenting to. Privacy statutes differ a little bit about what needs to be part of a consent request. And so here's some common elements that I can share with you. The consent mechanism or the request or the form or the survey, whatever it is, should obviously explain why the personal information is being collected and what it's being used for, who within the organization will have access to the information, including, I would say, service providers as well that are external but are still handling the data on your behalf, whether the disclosure of the personal information will occur on an identifiable basis outside of the employer, and if so, why are we sharing it outside of the employer and by whom? So, usually though, disclosure would be on an anonymous basis, perhaps to clients who are looking to understand, their suppliers' EDI programs and statistics, and also the consequences of not providing consent, which presumably are just the downside of not participating in EDI. We do not have an awareness of the relevant demographics of our employee population. We can't address inequities and the like. But you should outline the consequences of not providing consent. You should also outline the possibility of data being transferred outside of Canada. This is a general privacy requirement. If you're relying on, say, a data processor and they're located outside of Canada, you are allowed to have your data leave Canada for processing. You just need to be transparent about that when you're seeking the consent. And finally, who can answer questions about the program, whether it's someone in HR or whether it's a privacy officer. It's best to just have that follow-up as well. I don't want to get into the details and the weeds about the differences between federal, provincial, and public sector, private sector, that whole patchwork thing. I'm trying to stay at a relatively general level. But when it comes to consent, there are a couple of notable differences. If you're in the public sector, your consent has to state the legislative authority that you're collecting the information. This is usually your governing statute as an organization. And if you're in Quebec, Law 25, which is to say the amended Quebec privacy statute, has ratcheted up some of the compliance elements. And so your consent request will need to have some additional things, like the fact that individuals have rights of access and correction to their personal information, how it is you're collecting their information, which should be obvious in the circumstances, that they have the right to withdraw their consent down the road, and the possibility of communication outside of Quebec. This is a Quebec version of a foreign processing arrangement. It's just that Quebec, to my chagrin, treats the rest of Canada as if it was a foreign jurisdiction. And so you'd have to tell your Quebec employees if their data is being processed outside of Canada, outside of Quebec. Privacy statutes impose a data minimization principle, and sometimes it's called the limiting principle. And the limiting principle applies at the time personal information is collected, but also when it's used and disclosed downstream, and in deciding what personal information you keep over time. When does it get deleted? So when you're collecting information, you should limit it to truly what is necessary, what you have established as part of your documented program. And you should always anonymize personal information wherever feasible. It's both required in the privacy statutes. It's also a good idea because anonymized data does not present privacy risks if it was breached or inappropriately used or shared. You'll also want to ensure that what you do with EDI personal information is consistent with your consent. So you're going to avoid purpose creep, where new uses or new disclosures pop up that weren't part of the original consent. And then within your organization, you're going to want to strictly limit access to the EDI personal information. Bear in mind, I'm talking about the identifiable information. I'm not talking about the anonymous reporting or reporting with consent. It's the raw, so we'll call it the raw data, the stuff that you can see which employees are linked up with which EDI variables. And then access, as I say, access be on a need-to-know basis. If there is access or disclosure outside of your HR team or whatever the team that was identified in the consent is to occur, then you'll want to make sure that it's de-identified or anonymized or possibly aggregated in whatever way you framed it in your consent to individuals. However you describe the program to individuals is how you would grant access or disclosure outside of the defined team. Another important principle and set of privacy requirements is around safeguards. Privacy statutes require that personal information be protected, and your organization is responsible for all personal information in its custody or control. So even if you hire a service provider to collect EDI personal information for you from your employees and to kind of process it and bundle it up and maybe even never share it with you, only share aggregate or anonymized reports with you, even in that arrangement, you are still accountable for that personal information. And so if you're engaging a service provider, you need to make sure they are protecting the personal information at the same level that you need to. So to unpack safeguards a little bit, it's important that your safeguards apply to the full life cycle of the personal information. You don't leave a stage off in your thinking about safeguards. So you want to collect the information securely. You want to use it within your organization and share it within your organization securely. You want to store it when it's sort of at rest in a secure way. And even when it comes down to destruction, you want to make sure it is truly destroyed and securely destroyed. It's not just, a file's been deleted, but it's sitting in a trash bin for months thereafter. You want to make sure it's truly and permanently destroyed when it's no longer needed. One other element I'll mention, back to the previous slide. A few other elements I neglected to cover before I move on. You want to make sure that the EDI personal information is segregated from other data, that it isn't part of the general employees personnel file, but is kept separate, that you have audit trails logging who is looking at that data, so you can subsequently validate that the data is being handled appropriately. And just as an aside, if you're emailing the personal information, you don't want to email unless you're using a secure email and it's in a password protected attachment. That's an important safeguard when you're emailing information. In the event that the email lands at the wrong inbox, or there's too many people on the distribution list or so forth, they won't be able to actually see the EDI personal information because it's password protected. And as I say, once the personal information is no longer needed, it's securely destroyed. If your employment relationship is subject to a privacy statute, then your employees have rights under that statute to access and correct their personal information, and that includes their EDI personal information. And so it's important to bear in mind those access and correction rights, which include the right to know what information is held, how it is used, who it's been disclosed to actually ask for a copy of it, to correct inaccuracies or incomplete personal information as well. So that's a bundle of rights that privacy statutes give to individuals. And if you're subject to a privacy statute in the employment context, your employees have those rights. It isn't an absolute right. There are exceptions, but it's important that you keep those rights in mind and that you handle employee questions about how their EDI personal information, and frankly, their other personal information, that you answer their questions about how they're being handled and you do so promptly. There are strict timelines to responding to these rights requests, and the privacy commissioner can hear complaints. So if employees start asking questions or making access requests, make sure that you have you know what to do and how to properly handle those requests in light of your privacy law obligations. A quick word about privacy breaches. The good news is that anecdotally, I've not worked on any privacy breaches involving EDI personal information. And my theory for that is that because employers are actually quite careful with that data, that it is segregated. It's not in general HR or company systems. And so as a result, in my experience, it's not data that has been breached. If you do experience a privacy breach, whether of EDI personal information or otherwise, or you think you have, you should immediately involve legal counsel. It's important to involve legal counsel, whether it's your in-house counsel or external counsel, so that you can maximize privilege over the investigation into that breach and any resulting records, because inevitably some individuals are not going to be happy that their data was breached and you may face legal action as a result. So it's important to sort of extend the cloak of privilege over your efforts to investigate, contain, and remediate that breach. In terms of what happens if there's a breach, it varies by statute. And it also may vary based on the sensitivity of the personal information, although EDI personal information being relatively sensitive. But in any event, statutes can involve notices to individuals, notices to privacy commissioners, internal record keeping, or possibly nothing, depending on which statute applies. As an example, in Ontario, there is no statute that applies to provincially regulated employers, and so you can handle the breach in whatever way you feel appropriate without a privacy statute telling you what to do. Same with British Columbia. Although British Columbia has a privacy statute, it doesn't have a breach reporting regime, And so you're left to your own discretion. Again, important to know which privacy statute applies to you because there is variation across Canada. A final word is privacy commissioners. Unlike, say, individual litigation or union grievance or formal proceedings, privacy commissioners can get involved very easily. Employees can make complaints to privacy commissioners with very, very little effort. There's no cost to them. They don't need a lawyer. They just fill out an online form, submit it to the commissioner, and that will trigger a privacy investigation by the commissioner. The commissioners will always investigate complaints. They usually investigate by way of correspondence. And so, a few months after the complaint is lodged, you may get a letter from the commissioner asking some pointed questions, asking you to produce documents. They may ask you to produce your EDI program consents. They may ask you to produce your EDI policies. Sometimes it can involve interviews. All of this can be quite time consuming. And the real concern as well is if it starts to expand into adjacent areas, into other privacy practices. You do not want to be on the privacy commissioner's radar. Now, I will say the consequences of a commissioner investigation are largely about reputational damage. The commissioners will issue a report about their findings in a particular investigation that's made public, and it can name the offending organization at the discretion of the commissioner. And so you may find that there may be some reputational damage flowing out of it, but largely that's it. Other than in Quebec, those of you who are aware of Law 25 know that in Quebec, the commissioner has been given the power to impose fines, administrative penalties. Those of you that are paying attention to other privacy reform efforts, notably at the federal level, you will know that that is also contemplated. If that bill passes, the Privacy Commissioner of Canada will be able to impose fines. But in any event, what often happens, even if there are no fines from the commissioner, is that individuals, groups of individuals, unions, and others will use the commissioner's findings to further their own claims against an employer if there's a privacy issue. So hopefully this overview of the privacy regime and the statutes has been helpful. Nicole, I'll turn this over to you to talk about specific use cases for personal information related to EDI.
Perfect. Thank you, Daniel. So, of course, Daniel took us through a very comprehensive outline of how you go about collecting EDI data. I'm going to switch gears here and talk about how do you use that EDI data once you've collected it. Now, the first, I think, or the most common way that employers use EDI data, and certainly the one that I've come across most in my practice when clients call me about their EDI data, is with respect to special programs. So in terms of what are special programs, many people probably have heard of affirmative action programs, and that's commonly how they're referred to in the States, or kind of commonly how they're understood, but special programs is how they're referred to in Canada. So what exactly is it? It's essentially any program that's adopted by an employer or a service provider that aims to improve the conditions of an individual or group that's faced discrimination or historical disadvantage. And so briefly, it aims to resolve that, or to address that historical disadvantage, to rectify it in some way. Now, all special programs at the heart of them have a key difference, which is a distinction between equality and equity. And so what special programs are designed to do is achieve equity. And I'll give you an illustration on the next slide that really highlights what equity means versus equality. But essentially, special programs are designed to create equity. And they're protected by human rights legislation right across the country. And I'll just switch over to the next slide, where we have an image here that kind of highlights what it does. So it's essentially meant to even out the playing field. So equality looks at giving everyone the same tools to gain the same access to an opportunity. So here, very basic example, there's a ball game. There's 3 boxes, 1 each was given to each of the individuals there. That's equality. Everyone's given the same tools to gain access to this game, but unfortunately, it doesn't impact everyone the same. Here, only 2 out of 3 of the individuals are able to actually see the game. Equity looks at giving different people opportunities or different tools based on where they're situated. So here, as you can see, the man doesn't require a box and he still has access to the ball game. The middle individual, the child, has one box, gives them access to the ball game, and the last person, two boxes, and they're given access to the ball game. So it's looking at evening out the playing field, and that's really how we can look at special programs. Now, when you're creating a special program, it's important to note that essentially your data that you've collected is what has to drive both the creation of the special program, but also your implementation of that special program. So when we talk about special programs, really the purpose of it is twofold. It's important because it implements and addresses real disadvantage. So again, that's where your EDI data comes into play. You want to see what your data is showing you, and is there a problem within the workplace that you're looking to resolve? So for example, the underrepresentation of a certain group. Now, the second purpose of the special program is really to protect the organization from people who are not, who don't have access to that special program. And just to give you a very clear example of what a special program can look like, it could look like providing preferential hiring for a certain group of people who are underrepresented. So that could be, for example, women, it could be visible minorities, it could be Indigenous peoples, it could be any really disadvantaged group. Now, as I said, special programs are protected across the country in all jurisdictions, and some jurisdictions do allow for pre-approval, though it's not required. Ontario is an example of that, where you can get pre-approval for it, but it's not required. Now, when you're designing a special program, there's a couple of key features that you have to keep in mind. And again, your data should be driving all of these features. Now, the first, when you're coming up with a special program, there has to be a rationale. So the rationale is really, well, why are you coming up with this special program? If it's preferential hiring, why are you doing that? And your data, again, should drive that. Is there a problem that you're trying to fix? Does your data show that there's an underrepresentation of a certain group? Does it show that there's an underrepresentation at a certain point of employment? So for example, maybe you have good representation at lower level positions, but at management level, you are not seeing representation. So you have to have a good rationale, a justified rationale that's driven by your data as to why you have the special program in place. Now, the next thing to keep in mind is consultation. Now, once you have EDI data, not only is it a good idea, it's a best practice to consult with the groups that you're looking, the audience, for your special programs. So talking to those underrepresented groups to understand how can we eliminate barriers, say to promotion or to hiring, and getting their input so that your special program is well informed. Your data also will drive your eligibility criteria. So when you're deciding who's eligible for this special program, it should again be connected to your data. So for example, if you've discovered through your data that there's an underrepresentation, let's just say of a particular group, let's say for example, South Asian women, then you want to make sure that your eligibility criteria is connected to that. So you want to also be careful that you're not setting your criteria too narrow, such that you're not actually benefiting the people intended to be benefited, and also making sure it's not too broad. So just as a very basic example, criteria that would be too narrow is if, for example, or let's start with too broad. If you're, for example, saying that you want to increase the amount of South Asian women that you're employing, but then your special program is actually geared to all women, that might be too broad. An example of it being too narrow is if you said, we have a special program or a hiring preference, for example, for women of South Asian descent, but then you narrow it to a certain age, which might be an arbitrary criteria. That would be too narrow. Now, another way that you can use your data is to evaluate the effectiveness of your special program. So are you actually achieving what you've set out to achieve, your rationale as to why you have the special program in place? And again, that's where your data really will tell you if you're achieving that. So if you've set out to have the special program, for example, to increase representation, and you've done that this year, and let's say 2 years from now, you gather data again and you're not seeing any changes, that could be a sign that your special program is either not working, or it's not effective, or it's not essentially doing what it was designed to do. So your data really can help you understand that. Now, just very quickly, I'm going to touch on a second way that you can use the data that you've collected, and that's creating policies and procedures. Now, once you've gathered your data, sometimes that can give you a very good insight into the type of policies that would be useful in your workplace, or even policies that people within your workplace want you to have. So it allows you to create these policies, have a defined approach under those policies, and how to consistently apply things under those policies. The downside to sometimes having these policies, and I don't know if I'd call it a downside, but a risk, I would say, is overpromising. So sometimes if you have a policy that overpromises what you will do and you're not actually meeting those goals, then it can do a number of things, including decreasing morale. It can create mistrust in the organization if you're telling your employees, for example, that you're looking to have X amount of women in management positions and they're not seeing that. So it can result in overpromising and possibly not meeting your objectives. I'll just in the interest of time, just highlight some policies here that are examples of EDI related policies, and some of which can be directly responsive to the data that you've created. I know at least at Fasken, some of these policies are ones that we've put in place after gathering data and understanding what our employee population wants and wants to see in our policies. So these are just some examples here of policies that are EDI related and sometimes driven from your data. And then very quickly, before I hand it back over to Erin, is a third way that you can use your data, and that's to become a more proactive employer as opposed to reactive employer. Now on the slide here are just some differences of how you can be a proactive employer versus a reactive employer. Now, when you have data available to you, it allows you to take proactive steps. And that could be through a number of ways, such as what I just talked about, implementing special programs. So if you know what your employee population looks like, you can identify issues, you can identify areas where you want to ensure that there is more representation, for example. Having that data also allows you to create a positive workplace culture. Erin started off the presentation with some stats as to, do employees care about EDI? Do they care about an employer that cares about EDI? And the stats are overwhelmingly yes. And the stats are overwhelmingly that these things matter. And so being proactive and collecting this data can encourage that positive workplace culture, as opposed to being reactive and seeing, for example, that you have an underrepresentation or a discrimination issue, and you have a litigation or a complaint against the company, and then being reactive. So just in the interest of time, I will hand it back over to Erin to talk about some challenges, and then we'll address some questions that have come in from the audience, as well as opening it up to the audience to ask some questions.
Thanks, Nicole. So we know that with the collection of EDI data, there could be some challenges. And so we wanted to touch on some of the ones that most frequently come to our attention. The first one is low engagement. Employees may not feel comfortable in sharing this information because some of it can be quite personal and quite sensitive to them. And if you don't have a statistically significant group responding to the surveys, then the data isn't really all that useful. And so there are some solutions to that, around building trust. And I think that the trust comes from being really transparent about why you're collecting it, why you want to use it, and what the outcomes are. And it is important then to report on the findings and report on your successes and your failures, right? To be transparent about where the gaps are and what your steps are to try and improve that. I think it's also important the language around using it. So rather than asking people to disclose their data, changing that to sharing information. And as Daniel, I think, was referring to earlier, it's a good practice to have a prefer not to answer box for each of the questions, so that people can feel comfortable, because they may be willing to provide some information, but not open to providing answers to all of the questions. And that's fine. They have to be given that right and that opportunity to do that. And the other thing, one of the questions that came in, how do we know which options to give? Like, how many different options do we have to list for each question? Because surely we're going to miss some. And you're right. Like, there will be no way to include every single category. The Government of Canada has some questionnaires for different programs that they operate. And so they've got a good basis. I think you can use that kind of as a precedent. But if you have that box, either, for every question, have both an other and a prefer not to answer, then I think that's also helpful and will get people feeling as though they can respond. How and when to ask for proof. So you may be asking for applicants who come from certain backgrounds. You may be asking for, people from Indigenous communities, for example, to apply for positions, or they may be available or able to access different programs. But then how do you know? You can't just ask. Can you ask? How do you get someone to prove what their background is? And so I think, two of the things to keep in mind. One, if you're asking that question, it goes back to both what Nicole and Daniel were saying. You have to have a reason. So don't just be asking these questions and then not doing anything with that data. There has to be a reason why you're asking the question. And then the second point to that would be, maybe it's more important how people identify than actually getting to the legal analysis, asking for DNA samples or something like that. It's more important how they identify and how somebody chooses to live their life. So you could ask questions around that. And you could get them to sign a declaration saying, confirming that they're available to, or they qualify to access this program. And really, I think in most instances, you're going to want to leave it at that. And then the third sort of common challenge that we find is that you can get people who are claiming this sort of reverse discrimination, that now I'm being denied opportunities because they're being given to other people from different groups or protected groups that I'm not a part of. And certainly this is, something that's gained a lot of attention with our neighbors to the south recently. And when you think about the Supreme Court decision coming out of the United States, where they struck down affirmative action programs in universities. And so there certainly could be instances where you get these type of complaints. I've included two cases on this slide. One of the cases, the first case, Manitoba. Now it's an older decision, but I think it's an interesting one, and one that people may come across similar issues. This was in the hiring where the university decided to include affirmative action characteristics as part of their hiring process, and the union grieved because the collective agreement only allowed for skill, ability, and seniority to be used. And the arbitrator said, yeah, the collective agreement stipulates what you are allowed to rely on, so you can't just go off and start awarding points for diversity without consulting with your union partner. So I think the takeaway from that is to make sure that your unions are actively involved in any sort of special programs that you're developing, so that you can get their buy-in at the front end. And then the second case is an interesting one from British Columbia. And this is where it's a union employer in this case, and they instituted a program that was open for people from diverse communities. And a woman grieved because she said that was treating her unfairly. She identified as being white, although she was biracial. And so it's this interesting dynamic where she could have qualified because technically, scientifically, she was biracial, but she identified as being white and therefore said that it was not appropriate. And she was unsuccessful. Both the grievance arbitrator and then up to the Court of Appeal said that no, programs like this are protected under the human rights legislation, as Nicole set out in her presentation. So with that, we do have a few minutes left for questions. I know that there have been a mad flurry of questions coming in. I see Daniel has unmuted himself, so he'll jump in and field the first question for us.
Sure. Thank you. And thank you for all the great questions. We won't have time, I don't think, to answer all of them, but we'll try. And in that vein, I may speak a little quickly so that we can perhaps get a few more answers in as we're now at 1:00. One of the questions was, how do we be sure that if we use a service provider to help us with our EDA program and to process EDI personal information, how do we know they're doing the right thing? How do we know that they're taking care of that data in the way that we need to? First, before you onboard that vendor, that service provider, you should do your due diligence. You should ask them about their practices when it comes to privacy and really test those practices at an appropriate level. And I say appropriate because it's going to depend on the size and scale of your organization and how much data you're relying on them to process. But that's one aspect. Another aspect is to ensure that your contract with the service provider contains appropriate privacy clauses, limiting use, limiting disclosure, requiring safeguards, requiring they tell you about privacy breaches. So that's kind of the way that you would address the service providers. And I'll jump maybe to another question: who should and should not have access to EDI personal information? That is to say, the identifiable information that employees have shared as part of the EDI program. It's a bit of a glib answer, but it's whoever is supposed to have access. You've designed a program. The program presumably restricts access to the raw information to a limited number of HR personnel or personnel in perhaps an EDI office. There certainly is no need, unless the individuals have given you permission or employees have given you permission, there's no need for that information to be widely shared through the organization. So unless you have consent, it would be to a small group of individuals who need to see the information for the purposes of administering the program. There was also a question about what happens if you sort of suggest to the employees that it's an anonymous survey, but they're filling out the survey on their company laptops, and it's possible for IT to sort of connect the dots to a user and their survey response. Is that anonymous? Is that de-identified? Kind of what is that? It's likely de-identified. It would be important that when you receive the response, you de-link it from any identifying information that goes to the employee that submitted it. If you can sort of sever that and then move forward with that severed information, then you'd be able to say, look, our program runs on the basis of anonymous information. And so that would be my sort of recommendation. It's a bit of a technical question and something that's worth exploring. Just looking at some of the other questions. I'm not sure, Nicole or Erin, if there was one that you wanted to tackle as I look at the others.
Do you want to go ahead, Erin, or would you like me to?
Well, I was just, no, you can go ahead. I was going to do to close off and encourage people to
Sure. I think
so. If you do one more, then
sure. I know it's 1:03, so maybe we should be cognizant of just timing if you want to do the closing remarks.
Okay, so we've come to the end of our time today, so thank you so much. We really do appreciate the questions. This was an active group with lots of questions, and we love to see that on our end. And thank you to my fellow speakers. It is a lot of work, so I appreciate the time and effort that you put into this as well. For those of you in Ontario and Quebec, the CPD certificate or QR code is on your screen now, and there is a link within the chat. If you don't get to use the link, certificates will be sent out next week. For those from BC, the Law Society title has also been added to the chat as well, so you are able to use that. The next webinar in our 4-part series is on October 22nd, and the topic is EDI policies and trainings, common pitfalls and patterns. So please join us for that session as well. And again, the link is also in the chat. As always, if you'd like to register for any Fasken events, please go to fasken.com and look at the Fasken Institute tab. And please take a few minutes to fill out the survey. Thank you so much to everybody for coming. Have a great afternoon.